Isaac, can you hear me?
Hi, David. Yeah, I can.
All right, just checking. Isaac, is it Judith Amer who's going to be the hearing officer?
I believe so, yeah.
All right, is that how you say it?
Amer.
Amer. All right, thank you.
Mhm. And yeah, there'll probably be a couple commissioners who attend, but she'll be the one who's kind of the presides. Since it's a public comment hearing, it's a little different in that there's not like a strict set of procedure that she has to follow or anything, but she'll be kind of just the one to call on people and keep everything on track, so to speak.
All right, will she get, if they are members of the public, will they spell their name?
Did you get that list of people who are signed up?
Yes, I did.
I don't know that they will all have their name. A lot of people end up not doing that, but I try to update their names once they sign on if they don't have it listed, like if they have a company or something listed instead, or they call in on a phone number. There are two folks who signed up after that list was prepared. There's a person named John Reynolds, another person named Nancy Burns, who are not on that list, who will probably be here today.
All right. Burns, B-U-R-N-S?
B-U-R-N-E-S. Let me make sure, but I believe that's, give me just 1 second. B-U-R-N-S.
All right, and Reynolds, R-E-Y-N-O-L-D-S?
Correct, yeah.
All right, thank you.
Hello,
Hey, Judy.
how are you?
I'm good. How are you?
Okay, so the way I'm gonna handle this, well, first I'm going to ask any of the commissioners if they want to be the presiding officer. But I'm assuming they'll say no. And then, the NOPR says people who submitted written comments can still submit talk at the hearing, right?
Yeah.
For 3 minutes unless or longer. Anyway, I'm going to tell, however whatever the word is, that everyone go through and say their comments about the whole rule, except for the financial incentive, because that's the big contested thing. And then we'll go around one more time just on the financial incentive.
Hey, Judy, this is Nancy. Can you hear me?
Yeah.
Okay, I just wanted to make sure I didn't have to call in on my phone. I'm gonna mute it. Thanks.
No. Yeah, I can hear you fine.
Thank
you. Yeah. So that's the plan.
Yeah. None of the commissioners have mentioned anything. It sounds like they're all, a few of them will be here for sure, but I think that they're more interested in kind of observing than running things. I think you're probably going to be in a better position than anybody to moderate today.
Yeah, and I'm totally prepared to do that. In fact, I've been planning it, but I just don't want to be presumptuous. They always like it when you ask them. All right. Well, I'm going to mute for a second. I'll unmute in a sec.
Alrighty. Could I ask the person who's listed as NK what your full name is, just so we can reference you correctly in the transcript?
Hello, everyone. It is 1:30 and I would like to give at least another couple minutes to see if anyone else joins. And then I'll go on the record.
Very well, Judge.
I wish I were a judge sometimes, but I'm not. But thank you.
It's an old habit.
Yeah.
Judy, excuse me, this is Commissioner Hall. I can barely hear you. You're much quieter than David, for example.
Okay, I'll see if I can speak up. All right, I'm ready to go on the record. Good afternoon, everyone. This is the public hearing in case number 19-00296 UT in the matter of potential amendments to the NMPRC Rule 17.9.572 NMAC entitled Renewable Energy for Electric Utilities. This is the public hearing. There are several commissioners here that I would like to introduce before the hearing starts. And I would also like to find out if any of the commissioners would like to be the presiding officer at this public hearing, or if they would like me to do it. But that being said, we have Commissioner Stephen Fishman, Commissioner Cynthia Hall, and Commissioner Joseph Maestas here. And I don't know if they would like to say anything at the outset, but if you would, this would be an opportunity to just say hello or not, and let me know if you would like me to conduct the rulemaking.
Judy, this is Commissioner Hall. No, I do not want to conduct the rulemaking. I think you're fine to do it. But I just wanted to listen in. I'm just very glad that this rulemaking is going forward and you're having the hearing. That's all I've got to say. I just wanted to listen.
Thank you.
Hi, Judy.
Hi.
Commissioner Maestas here. I agree with Commissioner Hall. Please proceed and oversee these proceedings, but I just wanted to welcome everyone to this public hearing. Thank you.
Great. Thank you.
And Judy, I agree with our other commissioners present, and let's just go forward and do a great job.
Okay. Thank you. As everyone knows, the NOPR was issued in this case on, let me get the exact date, November 18th, 2020. After a series of workshops, we had initial comments and response comments filed. The NOPR does provide that the record will close on March 22nd. So there would be a week to provide comments after this hearing, I believe. And then the NOPR also provides that if you have submitted written comments, you can still make oral comments. We request that they're limited to 3 minutes. That being said, it can be extended if you're in the middle of a particular sentence or thought. My suggestion, after looking over all the initial and response comments, is to go through each person and have them summarize their initial and response comments on every part of the rule except for the financial incentive. I would like to leave the financial incentive to the end of once we go through the whole rule, and then we can just concentrate on that issue as a separate issue, because it seemed to be the most controversial and may require the most discussion, or may not, but it's just the way I perceived it. That being said, I would like to start with staff's comments. And it looks like David Black is here for staff. And so David, can you start with your initial and response comments?
Thank you, Presiding Officer Judy Amer. This is David Black, counsel for staff. My client, John Reynolds, is on the Zoom call too. So if any questions come up for him, please go ahead and ask. On the initial comments, staff suggests the addition of a new definition under the beginning with the letter E. Eligible renewable energy means eligible renewable energy resource means a long-term procurement of renewable energy by a utility from an unaffiliated independent power producer with a term of at least 20 years, approved by the commission pursuant to an application filed by the utility and with the commission on July 1, 2019 or later. Then staff suggests in its initial comments a suggested change to 17.9.572.16, a change to the title so that the title would read Cost Recovery for Renewable Energy and Carbon Dioxide Emissions Reductions, and here's the new information, comma, and for financial incentives, which we'll discuss later. And then also staff suggests inserting a new subsection E about the financial incentives. Also, a suggested change in the initial comments is to 17.9.572.20, adding a subsection G regarding the annual renewable energy portfolio report. G would read, describe and tabulate the utility's compliance with its renewable portfolio standard for a given report year, comma, relative to the first year a new standard becomes effective as established in subsection paren capital A of section, et cetera. I don't need to repeat it. It's all in the initial comments. Then staff goes on for a proposed rule section 17.9.572.23 in general. And with that, that has to do with financial incentives, which we will discuss later, as the presiding officer suggested. Now we will go to the response comments, I believe. Yes, I'm still going through the initial comments. Okay, so the response comments, which were filed on February 15th of this year. Staff initially notes that 1, 2, 3, 4, 5, 6, 7, 8 sets of initial comments were filed in addition to staff's initial comments. And the response comments go direct initially into the financial incentive or other incentive portion of the rule, which I believe is 17.9.572.23 proposed. And let's see. Oh, staff has a response comment about the renewable energy certificate. And that has to do with definitions beginning with R, renewable energy certificate, paren, quote, REC, all caps, close quote, close paren, means a certificate or other record, comma, in a format approved by the commission, comma, that represents all the environmental attributes from 1 megawatt-hour of electricity generated from renewable energy, and here's the new proposed wording from staff, delivered to a public utility and assigned to its New Mexico customers. And that has to do with clarifying that there are some investor-owned electric utilities in the jurisdiction of the commission that cross over to other states. But we want to make clear that this has to do with, the rule has to do with New Mexico customers. Okay, other than that, staff has some response comments about. I think I've exceeded my 3 minutes, so the remainder of the comments are having to do with the zero carbon standard for generation portfolio, definitions of carbon dioxide and greenhouse gas emissions, definition of procure or procurement, resource selection, voluntary renewable tariffs, and that's about it. I don't know if I missed anything. John Reynolds?
John Reynolds, are you available?
Oh, it looks like he's on the telephone right now.
Okay.
So,
All right.
I'll just stop it there.
Okay.
Thank you.
Well, thank you very much, David. Next, we will go to, I'm going to go in very random order the way the sign-up sheet was formulated. So is Adele Lee from Holland and Hart here? No Adele Lee. Is Pat O'Connell from Western Resource Advocates?
Hi.
Hello.
So Western Resource Advocates submitted comments jointly with Coalition for Clean, Affordable Energy. And in our written comments, we, in addition to noting that this rulemaking is necessary to make the changes on the renewable portfolio standards, also recommended adding additional language to address the zero carbon standard that is in the new law.
Oh, is that all you wanted to comment?
Yes.
Okay, thank you. Next, Stephanie Dzur from Coalition for Clean and Affordable Energy.
Hi, thank you. Can you hear me, Judy?
Yes, I can hear you fine, thanks.
So I'll just add to what Pat said. He said we had joint comments regarding zero carbon standard for generation portfolios. That is part 17.9.572.11. And our comments recommended adding language, and I'll just read it, it's very brief. In order to demonstrate compliance with this standard, each public utility must file every 3 years, beginning in 2021, a verified report that shows the carbon dioxide emissions from the resources it uses to serve New Mexico retail customers have decreased at least 4% per year from a 2020 baseline, so that the utility is on a consistent trajectory to supply 100% of its energy from zero emission resources by 2045. And we believe this additional language is necessary to effectuate the new requirement in 62.16.4A6 that utilities must make reasonable and consistent progress towards supplying 100% of its electricity from zero carbon resources. We think it's a good idea to make them put it in writing, to show it, to demonstrate it, so the commission can review that. So that's what this adds, is an actual document to be submitted and reviewed. It doesn't state that it's exempt from any waiver provisions. Utilities can still, request that. So that shouldn't make this in any way objectionable, but it's a good idea to be able to make this enforceable by making it reviewable. Thank you. That's my 3 minutes.
Oh, well, thank you very much, Stephanie. Next, there's 3 people signed up from Sierra Club: Jason Marks, Matthew Miller, and Joshua Smith. Would it be possible for one person to speak on behalf of Sierra Club?
Good afternoon, Chairman Fishman, Commissioners, Ms. Amer, Jason Marks, appearing for Sierra Club in this. I think my client may be monitoring this, but they've delegated me to comment. First of all, I want to thank the commission and for this NOPR and express our appreciation that the commission took into consideration our pre-NOPR comments and reflected many of them in the proposed rule. So we know that you're reading our stuff, and I expect that you've read our comments that we filed in here. So rather than repeat all of them, I want to focus on one thing, which is the implementation of 62.16.4B, and in particular B6. But 4B is where the legislature directed to the commission that the commission should administer the RPS and the zero carbon standard with several objectives in mind, to preserve reliability and to prevent cheating by redesignation and so forth. And what we have been recommending throughout is that the commission not read that section literally and put those words in the rules, say the commission shall do this and not do that, because that makes no sense. A rule is not the way, the commission does not make rules for itself. The commission makes rules for regulated entities, and we're asking that the commission look at this and say what is the legislature directing the commission to do in its rules, and implement these as rules governing utilities. And thus we proposed that the that the commission include in the rules that non-compliance with the standard should only be permitted to the extent that it not jeopardize the operation of a sewage treatment facility that captures and combusts methane gas. That's one of the standards in there. And also non-compliance can be only excused to the extent it's necessary to maintain and protect reliability. So we ask that your commission put those rules in place or those principles in place as governing utilities. And most importantly, or most controversially, I'd say, I think there's been support for that with others, but is the 16.4B6, which says the department in consultation with the Department of Environment ensure the standard does not result in material increase to greenhouse gas emissions from entities not subject to commission oversight and regulation. And it's our position that the legislature indirectly gave, obviously the commission does not have jurisdiction over these entities, but it told the commission that with the entities it does have jurisdiction over, utilities, that it should prevent those utilities from taking action that appear to help the standard, but in reality result in another entity increasing its emissions. And so the commission, our recommendation is that the commission write that into rule and state that an annual plan shall not result in material increases to greenhouse gas emissions from entities not subject to the commission oversight, as determined by the commission after it consults or in consultation with the Environment Department. So we're not asking that the commission take over some other agency's jurisdiction, but we're asking that the commission follow what the legislature delegated to it and actually implement that portion of the standard by making sure that a utility does not, that you regulate, does not take action that can be known in advance will actually defeat the purpose of the RPS by increasing greenhouse gas emissions. I do want to briefly say that in response, we didn't file response comments, but we agree with P&M and El Paso Electric that the reasonable cost threshold should be revised to make it clear that it is not necessary for the commission to revisit previously approved resources. We also support CCAE-WRA in having 3-year roadmaps showing linear progress, the percentages that Ms. Dzur was talking about to the zero carbon standard. For the same reason, we oppose the city of Las Cruces, who would delete reasonable and consistent progress language. We think that the commission should be monitoring this and keeping everybody on a glide path to zero carbon and not going along and just having a cliff at the end. Let's see. And with that, I thank you for your time, and I would answer any questions if there are any.
Thank you very much, Jason. Appreciate your comments. And next, I would like to hear from Mary Lee Sewells, if she is present.
Hello, yeah, can you hear me?
Yes, thank you. Good morning.
Thank you very much. I wanted to specifically request that in the definition of the reasonable cost threshold, which the legislation has stated is an annual average levelized cost of $60 per megawatt hour, that calculation needs some real definition. There are so many ways to calculate levelized cost that in this rulemaking, there should be a definition. What is the rate that should be applied to create the net present value over what time period? And what output assumptions should be used to do that? And exactly what is being averaged to determine that. Now that language is in statute, and I appreciate that the rule is restating it, but I believe the rule needs to go far deeper to define the calculation of annual average levelized cost. Thank you very much.
Thank you. Next on the list is Nicholas Kolunchik from the New Mexico State Land Office. If he is available, doesn't look like he is here, but, oh wait, I see an NK.
My name is Nicholas Kolunchik. I'm from the New Mexico State Land Office. I won't be, first off, thanks very much, and I appreciate everyone's participation. I won't be commenting today. We're listening and learning.
Well, thank you very much for participating. Next is Peter Gould from NMAREA.
Let me unmute myself first. Thank you, Judith. Thank you, Commissioner Fishman and other commissioners and commission staff and stakeholders. I'm Peter Gould. I do represent NMAREA, which is an organization of large consumers on P&M system. We filed both initial and response comments in this docket, and we wanted to thank you for the opportunity to file oral comments today. Very briefly, our initial and response comments basically said the same thing, which is that this rulemaking should be focused narrowly on those amendments to Rule 572 that are required to bring it in compliance with the 2019 amendments to the Renewable Energy Act. There were a number of other proposals. We feel very strongly that what we need to do in this case, what the commission needs to do, is keep that focus on bringing this rule into line with the 2019 amendments to the Renewable Energy Act, because we found in RPS cases it's quite confusing to have the rule out there unamended, and then the utilities have to comply, of course, with the statute. So it creates confusion, and it creates the need for multiple requests for variances. We believe that the other proposals that were made in this rulemaking can be easily handled in the rulemaking that the commission initiated in case 20-00158 UT. And with that, we'd say thank you. And if you do have any specific questions, we're not taking any, you'll see in our response comments, we've just commented on a few of the other comments in the case, and we've agreed with some and disagreed with others, but we're not taking any position on the comments that we didn't respond to. Thank you.
Thank you, Peter Gould. Next, I would like to hear from Zoe Lees, if Zoe's present, for SPS/XL.
Thank you, Judy. Zoe Lees here on behalf of SPS. First, I'd like to thank the Commission for having this rulemaking, allowing us the opportunity to make comments today and to file comments into the docket. I won't be summarizing every single comment we made on the NOPR, but generally I would like to say that SPS strongly supports making amendments to the rule in this rulemaking to implement changes made to the REA by the ETA. SPS strongly supports using the legislature's words rather than paraphrasing what's in the statute, so as to avoid ambiguity between the statute and the rule. And many comments made by parties in this case appropriately either seek to implement REA/ETA provisions by using the statutory text, or appropriately try to remove deviations from the statute. However, there are proposals that SPS in its comments argue should be rejected because they seek to contradict or effectively nullify the requirements of the REA and ETA. And so our comments do reflect those proposals which SPS believes contradict the statute. And lastly, I would like to say that SPS supports a definition of the RCT that does not retroactively analyze past approved procurements. It doesn't believe that is lawful. And I would just like to state that on the record today. Thank you.
Thank you, Zoe. Next, I would like to hear from Anastasia Stevens, representing, I believe, the city of Las Cruces. Is that correct?
Yes, thank you, Judy. It's Anastasia Stevens representing the city of Las Cruces. And I would like to thank the commission for all it's done. Can you hear me?
You are very fuzzy, Miss Stevens.
I am, oh dear. I'm speaking at my computer. Let me see whether there's anything I can do, maybe lift it up. So, can you hear me any better now? I've raised the computer a little bit.
Yes.
Okay, thank you. So the city of Las Cruces filed comments over the months because this case began with the workshop and earlier comment processes. And we were very pleased at the progress that had been made to come up with essentially a consensus rule on the necessary revisions. And our main concern at this point, which I know Judy said will be addressed later on, is with the financial incentives provision. As far as the nuts and bolts changes, again, we're very pleased that we are so close to consensus. The city has agreed all along at minimizing using statutory language. In fact, minimizing repetition of statutory language unless it's really necessary. In that regard, we recommend deleting section 17.9.572.12 that talks about the commission's duties to administer the act, because as I think Jason Marks said, there's no need to tell the commission, there's no need for the commission to put in their rule what they're going to do. I would like to clarify though, because he said that, and I think other people in their written comments have said, our concern about the phrase necessary and reasonable progress towards the RPS and zero carbon, and that shows up in sections 10, 11, and 14, maybe elsewhere, is a concern based on the possibility that a utility might use that glide path or smooth trajectory to evade the specific goalposts that the legislature has established. So we want them to be additive, not an excuse to not comply with the point by point. And our other nuts and bolts comments, other than the issue of the financial incentives, which we'll talk about later, has to do in sections 13, 14, 15, and 16, in terms of the RCT, resource selection, annual plan, and cost recovery. Is that better?
Excuse me, someone has a lot of background noise, and it would be helpful if
I just muted him.
Okay, thank you. All right, please continue, Anastasia.
In those other sections, 13, 14, 15, 16, this goes to a bigger theme that I know that the commission is planning to reach out and address, not necessarily in this case or in case 20-00158 UT, but based on their comments at the open meeting 2 weeks ago in the IRP, in the reassessment of the IRP process, is that given that within a few years now, 40% of utility energy is going to come from renewables. Renewables cannot be treated as a as a sideshow and a standalone thing. They have to be assessed in the same way that you would do least cost planning for all resources, because they are going to be a very substantial portion of all resources. So our changes, proposed changes in those sections, have to do with basically looking at transmission and other associated costs, and not just isolating the teeny bit of the actual energy procurement and renewable energy procurement. But when the decision amongst renewable resources is made, to look at the global picture for the overall cost impact on customers, whether that cost impact is recognized through an RPS cost rider, through base rates, through the fuel clause. We just want the most efficient result all around. And with that, unless there are questions, I will stay silent until we get to the issue of the financial incentives. Thank you.
We have signed up 3 people from PNM: Brian Buffington, Leslie Padilla, and Ryan German. And hopefully one of you could speak on behalf of PNM.
Thank you, Ms. Amer. This is Leslie Padilla on behalf of PNM. I'll echo the appreciation of the other commenters to the commission for getting this rulemaking finalized. This will be the 3rd year, I think, that we'll have filed a REA plan, so it'll be helpful to have a rule in place that does reflect the 2019 legislative changes. The initial rule that was attached to the NOPR, we did submit both initial comments and response comments. And I think on the initial comments, I will just note the one significant issue that we had was the definition of existing or proposed procurements. This is for purposes of calculating the renewable cost threshold. We believe that the RCT should just be forward focused. It should not be retrospectively looking at the RCT, the cost of existing procurements. I think most of the other comments that we made in our initial comments were relatively uncontroversial. However, in our response comments, we did comment on a number of comments made by the other parties and do have some concerns there. And I think insofar as those comments are concerned, I wanted to, actually I could just find my comments real quick, to just emphasize that the commission does need to have evidence to support its rules, evidence and support in statute also. And PNM believes there's no evidence or statutory support for several of the proposals that are made by staff and some of the other parties in the rulemaking, including the issue that I know, the staff's proposal that certain renewable resources should be limited to resources obtained through purchase power agreements. We believe that reflects a kind of a policy choice on behalf of staff, but not statute and not any evidence in the record besides their own comments. We also don't believe there's any evidence or statutory support for either the proposal of CCAE and WRA or staff to show these straight line reduction trajectories or linearly extrapolated standards. We certainly don't object to reporting requirements that explains the progress that we're making towards our RPS goals, but to suggest that there's a requirement for any sort of straight line trajectory, I think it was Jason Marks mentioned a glide path. Certainly, PNM intends to be on that glide path, but we don't believe that there's a requirement that we meet any kind of straight line trajectory or linearly extrapolated standard. Let me see what else I wanted to. We don't believe there's a statutory basis for some of the proposals related to greenhouse gas emissions. This concerns the issue that Mr. Marks discussed earlier, where the commission, in coordination with the Department of Environment, needs to ensure that renewable energy plans don't result in material increases to greenhouse gas emissions from entities that are not subject to emission oversight. We don't believe that's something that should be in the Renewable Energy Act. Certainly something the commission is required to do by the Renewable Energy Act, but it should not affect utility plans. I think that's all I wanted to mention. Again, thank you so much. We do have comments. Of course, we made comments both in the initial comments and response comments on the financial incentive. We'd be happy to speak later about those. Thank you.
Yes, thank you. And for this first round of comments, we will hear now from Nancy Burns from EPE. Nancy, you can unmute yourself.
Thank you, Judy. Yeah, this is Nancy Burns on behalf of El Paso Electric Company. And we've been participating, El Paso Electric has been participating in this docket prior to the NOPR. The utilities filed a joint utility rule, which has sort of informed some of the consensus process that's gone forward. And Judy, let me know if I freeze, because sometimes I will freeze on my internet here. I just want to say that we do support moving forward with a rule that conforms to the 2019 amendments to the Renewable Energy Act. Our next plan is due May 1st of this year. We're putting that together. We agree with the other commenters that there is a lot of consensus, in all the various comments. There are some clear points of disagreement, and a lot of that disagreement has to do with areas that may not have been expressly noticed in the NOPR. So we agree with New Mexico area's approach to maybe put some of those more contentious issues into the companion docket that we've all filed some initial comments on now. And if anyone has any questions, I can answer them.
Thank you, Nancy. At this point, I would like to ask if the commissioners have any questions of anyone regarding the comments made so far. Otherwise, I'll go on to the financial incentive section. Are there any commissioners who would like to ask any questions? Oh, that being said, I will now go in the same order regarding the financial incentive section and take comments from staff, either David Black or John Reynolds or both. Which one of you would like to make your comments regarding the financial incentive section of the rule?
This is David Black for staff, and John, are you ready? I don't see that you're there. Generally, I can say that staff, as to financial and other incentives, staff was unable to identify any other state where public utilities are granted ratepayer funded incentive, financial or otherwise, for exceeding the RPS. And for I think the providing incentives for reduction in the coal-fired generation. In addition, staff has concerns about language in the proposed rule that would encroach upon the environment a department's jurisdiction to measure. It's the Environmental Improvement Board of the New Mexico Environment Department to actually measure the quality of air emissions for carbon dioxide. Staff does not have the ability to do that. We don't have the ability to go out and verify in any scientific method carbon dioxide emissions or and in fact, the Air Quality Act expressly gives the New Mexico Environment Department's Environmental Improvement Board that duty. So John, you're with us?
Yes, I'm here.
Okay, and then finally, I wanted to note that our initial comments did in our actual formula language forgot to put a negative sign in the actual formula, and that appears in the errata to staff's written initial comments, and that errata was filed on February 2nd, 2021. John, did you want to address the financial and other incentives?
Yeah, just a little bit more. So staff put together a formula based on, as Mr. Black said, we had no basis or example to follow from other states that we were aware of. So we came up with a formula that we thought would work, and which is what the order in the NOPA required us to do. But based on reviewing those initial comments from other parties, staff has recognizes and shares the concerns that are raised by NM Area and OPL, or Occidental Limited, about a blanket formula for an incentive, which has a lot of analogies with prior attempts to set up an incentive, a blanket formula for incentives in the energy efficiency area. And so staff would, as I said, staff shares those concerns, and staff is supporting the guidelines that if the commission shares those concerns as well, staff supports the guidelines offered by OPL in this rulemaking. Thank you.
Thank you, John and David. I believe the first time around, we actually missed Robert London and from the AG's office. And I apologize for that. So Robert, could you make your comments now about virtually any part of the rule, either what we previously talked about or about the financial incentive? Robert, are you there? It looks like Robert is muted.
Judy, when Robert signed up, he said that he was primarily wanting to observe. He might not be planning on making a comment, so he might have had to step away or something.
All right. Well, I'll touch base at the end just to make sure if he does want to say something, because they did file comments regarding the financial incentive. That being said, we will go to, it sounds like Adele Lee is not available. Pat O'Connell from Western Resource Advocates.
Thanks for the opportunity. We haven't provided any comments on the financial incentive and don't have any to offer today.
Okay, thank you very much. Stephanie Dzur from the Coalition for Clean and Affordable Energy.
Hi, Judy.
Hi.
I don't have anything else right now. Thank you.
Okay, thank you. Jason Marks for the Sierra Club.
Thank you. I have a quick comment on incentives, but to respond on the comments in opposition to our position on the commission working in concert with the Environment Department, we think that's a matter of statute, and the commission will have to construe the statute. But to give an example of what we're talking about and why, so to put this in context, as the commission is probably may be aware, one of the alternatives that the utilities are discussing is converting their gas combustion turbines to use hydrogen to get to the zero carbon standard and have a reliable electricity supply. And to their credit, PNM has expressly said that they would use hydrogen that's generated from a zero carbon process like electrolysis. But the most cost-effective way of making hydrogen today is through processing natural gas. And you process the natural gas, I think it's with steam, and the output is hydrogen on one side, and then the carbon that's in the natural gas then becomes a CO2 emission or a carbon emission. So you can envision a scenario where a utility says we have a zero carbon generating resource. It's a combustion turbine that runs on H2 hydrogen. But the way they're doing it, the source for the hydrogen has CO2 emissions. The commission does not regulate the production of fuel normally, but if the commission, the legislature's intent is that the commission not permit a utility comply with the zero carbon standard by simply shifting the CO2 emissions or the greenhouse gas emissions upstream. And the rule that we're proposing would implement that in a way that is completely lawful and compliant with the REA. In terms of the incentives, Sierra Club does not have a position on how to calculate the incentives, as the other parties have demonstrated. That's a very fraught subject, but there's another fraught subject here, which is how do you distinguish between renewable procurements that are above the RPS and need to be incentivized from procurements that are being made because the renewable resource is the lowest cost, most prudent source for energy resources. I mean, today wind and solar are the first choice for energy. And so how are you going to distinguish if a utility goes beyond the RPS, if they're doing it for an incentive reason, or they're doing it just because that's the lowest cost resource? We don't have an answer, but we wanted to put that question to the commission to think about.
Thank you, Jason. Next, I would like to ask Mary Lee Sewells if she has a comment regarding the financial incentives.
Thank you. This is Mary Lee Sewells, and I do have a comment. I am here participating in this because of my interest in the impact on ratepayers and the people of New Mexico. These financial incentives are going to come directly out of the people who utilize electricity. And I would caution the commission to be very, very, very careful about how this is structured so that it's not simply a license to go into people's pockets without really changing anything important in New Mexico and in terms of achieving the renewable energy and zero carbon objectives set out by the legislature and statute. The renewable energy today is the cheapest energy that can be acquired or produced. I believe the challenges are going to have to do with how that gets integrated and managed and organized within the electric utility system. And that therefore the financial challenges are not related to the renewable energy, but they may be related to how the grid is managed and how the system is organized and operated. Please be very careful about structuring and rules something that simply is a green light to go into ratepayers' pockets. We need protection from that. There are huge challenges in front of us, and making our electricity more expensive than it needs to be needs to always be a consideration that gets extreme deliberation. So this is maybe the part of this that worries me the most. The opportunity for not having a break on spending money that comes out of ratepayers' pockets. Thank you for the opportunity to contribute.
Thank you very much. I would ask Nicholas Kalunchik, but it seemed like he said he just wanted to observe. So next I will go to Peter Gould, NMAREA.
Thank you, Judith. Our basic recommendation, which we included in our response comments on the incentive issue, is that this is one of those issues that should be put and considered fully in the 20-00158 docket, because we believe, as Ms. Burns said for El Paso, that there's a need to get this particular rule in conformity with the basic statutory amendments. And it would be helpful if the final rule came out with only those amendments in time for El Paso and in time for P&M to file their RPS case without having the confusion of two different standards out there. So that's our basic position on the financial incentives. But having stated that, if the commission does want to consider that in this docket, we've cited in our papers the 2011 New Mexico Supreme Court case, Attorney General versus New Mexico Public Regulation Commission, 2011 NMSC-034. The other citation is 150 New Mexico 174. And we believe that requires an individualized examination of each utility's request for financial incentives. Going along with what Ms. Sewell says, this is going to come right out of the ratepayers' pockets. And we think that case specifically says if you have an incentive, it's a rate. So any rate needs to be supported by specific evidence. It needs to balance ratepayer and shareholder interests. And in addition, we don't think, as Ms. Sewell very cogently stated, that there should be an incentive paid. And I think Jason Marks said the same thing. An incentive shouldn't be paid for actions that the utility would do anyway. And if it's choosing renewable energy because it's the cheapest option available, we believe that's within the requirements of these utilities that act in the public interest. They don't need to be incentivized to do that. So again, we'd recommend that this issue be fully explored in the 158 case, and that whatever procedure the commission does, that they adopt a procedure that's evidence-based. And as we stated in our response comments, we do think that Occidental Permian set forth a very cogent argument in their comments, and the commission should follow the guidelines set forth in those comments. Thank you, Judy.
Thank you very much. The next on the list is Zoe Lees from SPS. Would you like to make a comment regarding the financial incentive, Zoe?
Yes, thank you, Judy. And if it's okay with you, I'm going to keep my video off. Zoom keeps freezing whenever I turn it on, and it's very distracting when I am talking. So I would first like to say that SPS does believe that the commission needs to provide an incentive in this rulemaking. The REA now provides that the commission, upon a motion or application, shall open a docket to develop and provide a financial or other incentive to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standard. In SPS's last RPS case, case number 20-00143, we made such a proposal, and that proposal was postponed for a rulemaking. So to postpone it again when utilities are getting ready to file in May, June, and July their next RPS cases, postpones guidance on implementing what the legislature has stated the commission must do. Second, to summarize our comments on the financial incentive. First, the definition of the financial incentive in the NOPR limits the incentive to behaviors or actions that would not otherwise have occurred. This language, SPS argues, must be stricken as it conflicts with the REA and also conflicts with the plain meaning of an incentive, which is something that incites or has a tendency to incite determination or action. In its comments, SPS proposes an RPS incentive mechanism that takes into consideration both the proportion by which the public utility exceeds the RPS and the size of the public utility's load that is subject to the RPS. It's logical that a public utility that exceeds the standard by a greater amount should receive a greater incentive, and that incentive should also take into account proportionality relative to the amount of load served by the public utility. The incentive mechanism should also ensure that recovery of the incentive once earned takes place relatively close in time to the period for which the incentive was earned. And finally, the incentive opportunity should be applied from the effective date of the ETA. Those were the comments that SPS made on it, on the incentive. In addition to the red lines, it attached to its initial comments, and I don't need to go into those unless you would like me to, Judy. I think I've probably gone over 3 minutes.
No, that's fine if you would, if you don't want to talk about the red lines in your initial comments.
Just to say that I think they stand for themselves and that they are in the record, and they're in the record as part of 572.23, and they're quite lengthy, which is why I don't think that I should recite them all here. But those red lines do provide SPS's specific recommendation for the incentives, and SPS believes it is that its proposal is proper under the Renewable Energy Act and should be implemented by the commission in this docket.
Thank you. Anastasia Stevens for the City of Las Cruces.
Thank you. I'm going to respond first to SPS's comments because they are in a peculiar situation. And I understand that they made a request in their docket and it was deferred to a rulemaking. There is another rulemaking, it's 20-00158 UT. For the rest of us, and that I guess OPL is in the SPS case, but the rest of us are not a party to that case. We do not know what developed in that case. We did not have the opportunity to make an evidentiary record in that case. So they just cannot steal this rulemaking and come in and say, the commission must do something now because they're going to file another case this year. It's unfortunate for them, but that's true. It's plain that the issue of incentive mechanism is controversial. It's too controversial to let it be done with no record in this proceeding. If you look at the formula that SPS proposed in this case, amazingly, there's no dollar churn. Ms. Lees just described it as being proportional to the amount of excess over the RPS requirement and the amount of total jurisdictional energy sold. That's all in megawatt hours. And AG pointed this out in their response comments. Maybe they stuck $1 in front of that number. Maybe they didn't. But if you read their comments in this case, there's no way of knowing that. The only single number in this case is that SPS kind of, as a gesture, said, well, we should cap it at $10 million. I assume they mean $10 million a year. And to the extent that rates, charges to customers always have to be cost-based and reasonable and just, there's just nothing here to support that. As far as PNM's and EPE's proposals go, and staff's proposals, well, this commission, nobody in this room, except maybe in the back of their heads, has any knowledge what the dollar impact of those proposals would be this year, next year, 3 years from now. There's no way on earth that the commission can legitimately issue a rule without that knowledge. And in our initial comments post NOPR, the city raised legal concerns about the extent of notice and whether the statute calls for individual cases or not. We don't even have to get into the fine points there. It's just common sense that the commission does not, as Mary Lee Souls just said, authorize tens of millions of dollars of ratepayer money being sent to utilities when they don't know what it is. It's just inconceivable. And in a similar vein, I'll go back to the points that I had earlier, is that it surfaces in the incentive formulas and elsewhere in the comments that, as Mr. Marks just said, and Ms. Souls, when renewable energy is now the most cost-effective source of energy for utilities, where do you or should you continue to draw the lines? And the legislature sort of kind of made some movement in that direction in the 2019 amendments to the Renewable Energy Act by saying that renewable acquisitions must be done through a competitive procurement process, but they didn't go all the way and say it is one big competitive procurement process. So I believe the commission, either in case 2158 or in another IRP rulemaking, which they referred to a couple of weeks ago at open meeting, needs to really get into what the new paradigm is for utilities in New Mexico before they start charging customers piecemeal for things that they don't know what they are. The city, wants to help, but fundamentally the commission has, since 1941, has had two big duties that the REA does not change. One is to establish fair, just, and reasonable rates, and the other is to provide for the extension of utility service without unnecessary duplication and economic waste. The financial incentives provisions that have been proposed, aside from having no evidentiary basis and being, unacceptable in that regard, they do not address these fundamental requirements of utility regulation. And the city begs the commission, pleads with the commission to remember that and take care to respect your overriding obligations as a regulatory body. Thank you.
Thank you very much, Anastasia. Next, we will go to PNM. It appears that would it be Leslie Padilla speaking on behalf of PNM?
Yes, it's me again, Ms. Amer, Leslie Padilla. I wanted first to respond to NM Area's argument about the 2011 Supreme Court case, controlling the incentive question in this case. And I wanted to note that the Attorney General in their response comments explained that reading, the NM Area's reading of that 2011 opinion is not accurate. And I would encourage you to go read that portion of the Attorney General's comments, and PNM agrees. Even if the case does apply here, as PNM pointed out in its response comments, the formula that PNM and others have proposed are in fact consistent with that decision, in that the rates, or the incentives, I should say, would be cost-based, utility-specific, and based on evidence. This is very similar to what we do now in our energy efficiency cases, which is provide the basis for the energy efficiency incentives each year. In our response comments, we also objected to staff's proposal that any incentives should be limited to renewable resources that are acquired only via a PPA. It's our opinion there's no basis for that limitation. We did provide a formula for the incentive that applies to the renewable, the exceedance of the renewable portfolio standard, but we noted that the statute actually does provide for 2 additional types of incentives. PNM thinks it's appropriate that those simply be allowed to be proposed on a case-by-case basis. However, we are concerned that what happened with SPS in their last renewable case and the development of this rule, we don't want a situation to develop where utilities don't have a means of accessing what's clearly allowed for in statute. And on that same point, to some of the other comments, Ms. Sewell's, the City of Las Cruces, there is clear language in statute that allows utilities to seek incentives. And we haven't heard from them. All we've heard is that they really don't want that statutory provision to have any meaning at all. We don't think that would be appropriate for the Commission not to actually implement that language. And I just briefly wanted to mention, to respond to something to what Mr. Marks commented about the example of the gas to hydrogen plant. That's kind of an example of why we don't think this needs to be in the Renewable Energy Act rule. That proposal of a utility to convert its gas plants to hydrogen wouldn't touch the Renewable Energy Act at all. There would be no place for it, as far as I can tell, in our Renewable Energy Act plan, since hydrogen is not a renewable resource. So while his concerns may be appropriate, we don't believe they're appropriate in the context of Rule 572. Thank you so much.
Thank you. And now can we hear from Nancy Burns for EPE?
Thank you again. I'll just make this really brief. I would like to point out that EPE has also recommended that the proposed definition of financial incentive not be included in the rule as drafted. We think it conflicts with the statute. I think that EPE, in its initial comments, made a proposal for an incentive formula. I think that the other utilities, PNM and SPS, also made proposals for formulas for an incentive. EPE agrees that those proposals should not limit the types of incentives that are available under the statute, and that those proposals in and of themselves are a means to ask for an incentive with the types of guardrails that Oxy has recommended in their
You have frozen, Miss Burns,
Oh, okay. Can you not hear me?
No.
which Oxy recommended in their comments.
Yeah, can you hear me now?
Yes,
Yes,
ma'am.
yes.
Oh, okay. Anyways, I believe that all three of the incentive proposals that are on the table in this rulemaking, none of them in and of themselves is setting a rate. The rate themselves would be actually set in the individual cases, pursuant to the evidence. They'd be cost-based. The commission would review them. So that's pretty much, I just wanted to make sure that it was clear that we do recommend that definition of financial incentive not be included as written in the rule. And we made a incentive proposal, and we think that all of the incentive proposals comply with the guardrails that Oxy has set up and argued in their comments. That's all.
Thank you very much. I've gone through the list, and the only one who hasn't spoken is the Attorney General, Robert London, and I don't know if you would like to make any comment, Mr. London?
Hi, Ms. Amer. I did not request any time to speak today. I was just observing, but I would just like to say that our comments are best made in the written form that has been filed in this docket. So thank you.
Okay, thank you. And is there anyone else who would like to make a comment at this time? Any of the commissioners? I'm not sure any of the commissioners are still present. Yes, Commissioner Fishman.
Yeah, lots of debate over the financial incentive. And I guess I'm gonna plead ignorance of the statute. The statute says may provide an incentive or shall.
The statute allows the utility to collect an incentive, and it provides that the commission shall establish rules regarding that.
So it allows it, but it doesn't mandate it.
Well, in accordance with whatever guidelines and rules that we establish.
Okay. Thanks.
Judy, I have the statutory language in front of me if you'd like me to read that provision.
Yeah, that would be excellent, Zoe. Could you do that?
Yeah, so that provision states, upon a motion or application, the commission shall open a docket to develop and provide financial or other incentives to encourage public utilities to produce or acquire renewable energy that exceeds the applicable annual renewable portfolio standards set forth in this section.
Okay, thank you. That helps a lot.
Yeah, so they apply and then we decide. And as Zoe stated, SPS did make a request in the 19-134 docket. And at that time, the commission stated that we needed to establish guidelines. And that is how it got included, the financial incentive portion of this rule. That's how it got included in this NOPR.
And I wanted to follow up on a comment by Mary Lee Souls, where we're talking about levelized cost. And I think she's very much on point that we need to add definition to that. Levelized cost over the life of the project, levelized cost over, there are so many things that need to be defined in that calculation, and that we really should take a close look and be sure we get it clear and get it right.
Yes, Commissioner Fishman, and the record does remain open until March 22nd. And we haven't really received, as far as I can tell, any comments discussing that particular issue. And somebody can
So,
correct
so
me
if
if I'm wrong.
I can submit comments between now and then?
Yes.
Okay, terrific.
Is there anyone who would like to?
Excuse me, and Ms. Amer,
Yes.
would folks who have already submitted comments in this document be able to submit additional comments before that deadline?
Yes, the record remains open until March 22nd.
All right,
according to the
thank you.
number.
And Miss Amer, this is Peter Gould. I wonder if I could just make one brief comment in response to what PNM said on our comments on the financial incentive.
Yes, please go ahead.
The real problem with providing these kinds of formulas is they do not allow the commission to really do a comprehensive look at the rate that's being proposed. For instance, if a utility was already over earning, we believe it would be entirely improper under the case that I cited to allow for an incentive. And these formulas do not allow any commission leeway. So they take away the commission's ability to determine whether the proposed rate is just and reasonable, because they try to lock the commission in to this formulaic approach. We agree that the statute does allow for utilities to apply for an incentive. That's clear. And we do believe that if the utility shows that it needs an incentive to add additional renewables, an incentive is appropriate and proper. We do not believe, though, that the commission should accept any formula that ties its hands to determine whether that resulting rate is just and reasonable. And that's really our point. We're not saying that the statute shouldn't be followed. Thank you.
Thank you. Is there anyone else who feels like they need to make an additional comment?
Ms. Amer, I thought I heard Chairman Fishman say that he had another week to make comments. And if I heard that correctly, I just wanted to state, and that this is certainly for General Counsel, it's in your wheelhouse, not mine, but having litigated some of these things, that a commissioner cannot make comments into a rulemaking, because that would be bootstrapping, making your own evidence. I mean, you can make your own evidence, Chairman Fishman, but not directly. You would, is my understanding. You're going to need a record that is from the public to base a decision on.
Thank you.
Thank you, Jason. Any other comments? Seeing that there are none, I would now like to conclude this public hearing. As I stated previously, the record in this matter closes on March 22nd. Thank you. Goodbye,
Thank you.
everybody.
Thanks,
Ready?
Judy.
Thank you, Judy.
Thanks, Judy.
Miss Amer,
Yes,
how do you spell NOPR?
it's an acronym, all caps, NOPR.
Thank you.
Thank you, Judy. Nice job.
Good
Thank you
job.
very much. Thank
Take it
you.
easy, Jason.